Hi, everyone. Harry here to talk about the latest moves post-verdict in the Rudy Giuliani, Shaye Moss, Ruby Freeman defamation case. All right. First point, there were the plaintiffs, Moss and Freeman, did two things yesterday. It's being reported as a new lawsuit. That's not really right. Here's what's going on. The court retains jurisdiction over the case for a time. And in fact, there's an automatic, under the rules, 30-day stay of execution, at the end of which she will enter the judgment of $148 million and make the sort of legal official changes to the party's rights and responsibilities. Giuliani's having the responsibility to pay $148 million. That will trigger certain, the ability to do certain things by Ruby and Shaye, most particularly to be able to try to go out and that they become official creditors, as with other creditors of Giuliani's, of which there appear to be many, including former lawyers that he's just stiffed, and try to jockey, get in line, attach assets, and the like. An important point about this judgment is it can't be discharged in bankruptcy. So even if he commits bankruptcy, he still owes this to them. Not to say that means he'll pay it all, but that's a sort of, can't get blood from a stone principle. Anyway, Giuliani, incorrigible jerk that he is, moron that he is, something addled alcoholic that he is, continues to defame Moss and Freeman, including the first day of the trial when he said on the court steps, everything I've said is true. They rigged the election. And even after, with this bizarre and really offensive, especially given his track record of flagrant lies, suggestion that, everything he said is still true, but he just wasn't able to present the evidence. And, maybe at a future date. That's like laughable now and worse, because when do you present the evidence except at the very trial when you're going to be held liable for it? So what does he have up his sleeve? Almost certainly nothing, but legally it's nothing because he has lost now, and he's still out there basically defaming them and suggesting that there's evidence that just wasn't presented, or that he didn't have an opportunity to present. That's a really bald-faced lie, and a very straightforward one. Of course, he had the opportunity, including by testifying himself, as he promised to do all week. Then the real truth would come out, but didn't. So they've gone to the judge now, Moss and Freeman, and they've done two things. The first is, and it's key, that the judge, while this 30 days are pending and maybe after, still has jurisdiction. So they're saying, you still have jurisdiction. You haven't entered the final judgment yet, so you can do these things. Whereas after it's over, they might have to bring like a whole new lawsuit, get in line in whatever court they're in. We may see this happening, by the way, a separate lawsuit saying, okay, we've got our judgment, now force him to pay if necessary by, sending marshals to attach his holdings, his apartment and the like. But for now, they are trying to leverage the fact that there is still jurisdiction in the district court with Judge Beryl Howell. So they're saying, A, give injunctive relief in the form of an order telling him to stop defaming us. It's not, as has been reported, a separate lawsuit for defamation, though it could be if they wanted. This is kind of what happened, right, with Clinton in the second defamation trial that he's facing. He just kept doing it. They could, but they haven't sued. They've just said, please enter injunctive relief. And in support of that, they've said, they filed a demand with his lawyer saying, stop doing this or we're going to go to the court. And Giuliani told him to pound sand. He refused even to say, in the wake of this $148 million verdict, that he would stop doing this for now. So they're going and saying, you've still got jurisdiction, order him to shut up. it's not exactly a cause of action. It's not a normal kind of ruling, but they've got the leverage of having jurisdiction. So in the same way, a judge could find somebody in contempt. It could just enter an order, Mr. Giuliani, while you are under my jurisdiction, you're not going to continue to defame them, or they'll be hell to pay. It's an unusual order, but I think it would hold up, and she could well enter it. Just button your zip it for now. That's the first thing. Second thing, more important. Here's what would typically happen. They would have to wait until they have that piece of paper that's a judgment that says this guy owes us $148 million. And under the Constitution, that piece of paper has to be honored around the country. That's what full faith and credit means. So they can go to Nevada if he has property there, or California if he has a bank account there, and present it to people and say, this is a judgment for $148 million. It's out of DC and you must honor it. But they need the judgment, and that's a matter of some 30 days. And they have reasonable apprehension that during those 30 days, who knows what hijinks Giuliani would pull? Who knows if he would give whatever meager resources he has, or maybe more, maybe his nest egg in the Cayman Islands, to other creditors, and just to sort of spite Moss and Freeman. And then when they come after him, oops, all gone. Try to do things to hide, etc. So what they want to say is, can we accelerate the timeline, please? So the future of 30 days is now, and we can start right away going to other states, attaching his assets before he has an opportunity to really hide them, convert them, get rid of them, and do things that would generally foil the verdict even more than is already going to happen, because I think it's commonly accepted that no way they're getting near $148 million. Okay, a final point on that, by the way. Typically when you see a jury verdict for 3 times as much as the plaintiffs requested, your thought is a court of appeals is going to really reduce that. They're going to say that a big chunk of it was due to sort of inflamed prejudice or illegitimate enmity on the part of the jury. And, that could still happen here on appeal. Of course, as I'm suggesting, I don't think it really matters practically. I think the difference between what they would reduce it to, even if they cut it in a third, would ever get to the practical ambit of where he has money to pay them. But that's the first thing you think about. I just want to point out that here there's some special circumstances that make it at least a little bit more of an uphill climb for Giuliani. The first is they were careful, was the jury, to they asked for the PowerPoint by the expert who really went through step by step what it would take to compensate the plaintiffs for their reputational damage and just the complete upending of their lives. And that's what they took. The way they got to so much more is they added a big chunk of change, more even than compensation for pain and suffering, $20 million each. And then they added an even the biggest amount for punitive damages. But he certainly showed himself to be deserving of that by his incorrigibility, the nastiness of some of the things he said, the complete fantasy, etc. So, and especially the incorrigibility, which of course caused the judge to actually hold against him on the underlying merits of falsity and knowingness, so the cause of action of defamation. So one point here is it's not simply a crazy number plucked from the sky, but it's a methodical number that they put together. And then the second point is he gave them literally nothing to work with on the other side. He didn't testify. He had really the only evidence that his lawyer even pointed to in closing argument was evidence that they had presented. Some of the statements he'd made, and sort of weird speculation that, it's terrible what happened, but you can't say that Giuliani caused that, and the like. So those are two legal factors that would normally cut against what you'd expect when you see the sort of sticker shock of a jury verdict that is 3 times what plaintiffs asked for. Nevertheless, the main point here is all of that amount that a court of appeals could work with is secondary to the real dollars, whatever they may be. He has fastidiously kept us and the court from knowing so far. And the more important point for them is trying to get at that. And we'll see if the judge does something unusual here, which is to say, I know the rules say I got to wait 30 days, but I'm going to move this up or otherwise give you the wherewithal to go after him now and try to attach his funds and assets before he does something to, put them out of reach to you. So that's the motion to watch most carefully. And then there's also the possible order saying, just stop defaming them, Rudy Giuliani, as long as you are under my jurisdiction. So those are the next moves. And then in this long saga of what does Giuliani have in mind at the very end of the day, is it just by, continuing to be, completely recalcitrant, oppose every move, and turning out to be insolvent? We'll see soon enough. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.